My name is Jordan Ryan, and today I am Blake Van Owen.
Good afternoon, Your Honor, members of the jury. My name is Ella Walters, and today I am Taylor Perkins.
Good afternoon, Your Honor, members of the jury. My name is Olivia Longi, and today I am Avery Becker.
Thank you. At this time, I'm going to ask anyone who is not addressing the preliminary matters to turn off their camera. Thank you. For the prosecution, what are your preliminary matters?
For virtual competition, may we consider the stipulations and our trial roster published to the jury, opposing counsel, and Your Honor?
Yes, you may.
And although Rule of the Competition 5.1.1 requires attorneys to stand during openings and closings, because we are virtual, we ask that the court waive that requirement for both teams.
Yes, the court does waive that requirement. You may stand if you wish, but you do not need to.
And Your Honor, when we introduce exhibits under Rule of the Competition 7.4, we will direct the witness to the exhibit for identification and authentication, ask for admission, and if admitted, publish to the jury by screen share. This procedure complies with the rule.
That's acceptable to the court. Anything else?
The prosecution is ready for trial, Your Honor.
Thank you. Is there anything for the defense?
Yes, Your Honor, we have a few preliminary matters as well. First, we ask, when an objection is sustained, would you like us to move to strike the testimony or consider it stricken?
Request to strike the testimony.
Yes, Your Honor. We also ask if at any time the court cannot see or hear a lawyer who is speaking, a witness who is testifying, or an exhibit being displayed, we ask the court to interrupt so that the problem can be resolved, and we ask this on both behalf of the prosecution and defense.
Yes, if there's any technical issues that need to be resolved, I would ask any attorney of record at that time to please interrupt and notify the court or scoring panelists can stop it as well to address the issue to make sure it's fair to all parties.
Yes, Your Honor. And lastly, we ask in accordance with Tournament Rule 7.4 that both attorneys and witnesses, as well as trial technicians, be allowed to annotate exhibits after they have been admitted with Zoom annotation features.
That should be fine. I would request that you ask the court's permission at that time regarding any changes that might be made to exhibits.
Yes, Your Honor. The defense has no further preliminary matters.
Objection, Your Honor.
Yes.
Rule 4.6 states that the attorney presenting the opening statement shall present the preliminary matters.
Is there a response?
Could I ask opposing counsel to clarify?
Sure. I
Sure.
believe in the rules it says that the attorney who will provide the opening statement is the attorney who is required to present the preliminary matters.
At this point, I'm going to allow Ms. Combe to address the preliminary matters, and in the meantime, I will consult, you said Rule 4.6?
I believe so.
Okay. Anything else, Ms. Combe?
No, Your Honor. The defense has no further preliminary matters.
Anything further from the people?
No, Your Honor.
One last preliminary matter from the court for all parties to be aware of is this court's practice and procedure not to allow recross-examination except for under exceptional circumstances. If you believe that the circumstance calls for it, you may ask the court for recross-examination, but just note it is not this court's practice to allow it. And I believe we are live. opening statement on behalf of the prosecution.
Your Honor, opposing counsel, and members of the jury, Avery dealt with the devil and got burned. The defendant, angry at her coach for the loss of her mock trial dream, broke into the victim's house to trash it. The burglary went tragically wrong when the victim appeared armed with a knife. A struggle followed, and what started as a prank ended with the coach dead on the floor in a pool of blood. On the shoulders of the prosecution rests the burden of proof to prove beyond a reasonable doubt that Avery Becker is guilty. Avery is charged with murder in the first degree, felony murder, and second degree burglary of a dwelling. Avery unlawfully and knowingly broke into a home with the intent to cause criminal mischief, to play prank, to trash the place. In those course of events, Mackenzie Brockman was stabbed in the back with the very knife he held to defend himself from the intruder. To meet that burden of proof, you'll hear from 3 prosecution witnesses. First, Detective Jordan Markowitz, lead detective and expert in this case. Detective Markowitz will place Avery at the scene and time of the crime through cell tower data, a field she is an expert in. Detective Markowitz will also detail how she determined Avery being the culprit, including motive. Next, you'll hear from Alex Cifuentes, who is Avery's friend and fellow teammate. He will show you all the rising tensions between Avery and Brockman, the victim, from Avery's bad habits to vandalism to text messages where Avery threatens to do exactly what happened. Finally, Kyle Kuzak, who is a crime scene reconstruction expert. Kuzak will walk you through exactly what happened during Mackenzie Brockman's murder. The defense will present 3 witnesses of their own and listen to the cross-examination of these witnesses. You'll hear from Taylor Perkins, who is Avery's friend and loyal to a fault. Taylor will tell of Avery's strained relationship with the victim. Taylor has done many things for Avery, like quitting mock trial, skipping school, and now alibying Avery. Taylor has saved Avery before and is trying to do so again. You'll hear from Blake Van Owen, an ex-police officer and paid witness who only ever testifies for the defense. Van Owen offers nothing more than assumptions of her own. Van Owen also offers a suspect who is vaguely linked to the victim rather than the direct connection Avery has. Finally, Avery Becker, the defendant. Avery was a student on the mock trial team under late coach Mackenzie Brockman. Hostility was high between the two, and Avery often lashed out, whether it be storming out of practice, vandalism, breaking into, and attempting to trash a home. Every mock trial practice, there was various arguing, pranks, and heated reactions. Now Mackenzie Brockman is dead. Avery has the means. The defendant trashed a car once before. What's a house now? Avery has the opportunity. The defendant wasn't in school the day of the murder. Avery has the motive. The defendant got mad and trashed a car. And the defendant got mad once again and broke into a home. Why we are here today is no light matter. There is a dead body and a bloody knife. This is not a mock trial case students worked on in their free time. This is a prank gone wrong, but every action has consequences. At the end of the presentation of evidence, my co-counsel Zoe will ask you to find Avery Becker guilty because Avery got in, got out, and got even. Avery dealt with the devil and got burned. Thank you.
Thank you. Opening statement for the defense.
Yes, Your Honor. May I have a second to prepare my space?
Yes, briefly.
Okay. Just to confirm, can you see and hear me?
Yes.
Okay. I am ready to begin. Too many questions, not enough evidence. On March 6, 2020, Detective Jordan Markowitz of the Denver Police Department arrived at the scene of a murder. The body laying on the ground, dead, was that of local attorney and high school mock trial coach Mackenzie Brackman. The only thing the police found was a bloody knife laying on the ground and a few videos of a masked assailant who was covered head to toe. And the police struggled to find any other evidence. So, as you heard from the prosecution today, they constructed an easy story, one of dealing with the devil and it going wrong. They decided that the murderer must have been a competitor on Mr. Brackman's high school mock trial team. So they found Avery Becker, a student at Colorado High School who had been kicked off that very same team. They dug up any plausible piece of evidence they could find, and now, members of the jury, my client Avery Becker is fighting for her life. However, as you will see in today's case, the prosecution simply has too many questions and not enough evidence. Now, Ms. Becker has been charged with the crimes of burglary and murder in the first degree, which means it's going to be the job of the prosecution to prove to you today that Ms. Becker knowingly entered the residence of Mackenzie Brackman with the intent to commit a crime, and in the process of committing that crime, caused the death of Mr. Brackman. And it's going to be their job to prove this to you beyond a reasonable doubt. But as you will see in today's case, they will not be able to do that because there are simply too many questions and not enough evidence. Now, we're going to ask you to focus on 3 questions in today's case. What about the alibi? What about the motive? And what about the investigation? So first, what about the alibi? Now, you're going to hear in today's case that Avery Becker had a rock-solid alibi, but you won't have to take her word for it. Another witness, Taylor Perkins, will confirm every bit of Miss Becker's alibi. They'll both tell you they spent the entire day at the mall, never even thinking about Coach Brackman or mock trial. And even though the prosecution will try to bring up cell tower data that they say disproves this alibi, you'll hear from Professor Blake Van Owens that, well, this data can't do that because it can only tell us where Miss Becker's cell phone might have been. But that brings us to our second question. What about the motive? Now, the prosecution has told you about text messages they say prove Miss Becker's intent to commit a crime. However, you'll also hear that even though the police had the means and opportunity to verify whether these text messages were legitimate, they didn't go to the trouble. And that brings us to our third and final question. What about the investigation? Now, you're going to hear in today's case that, well, the police's investigation was dangerously incomplete. You'll hear that they never even bothered to locate one of their primary suspects, someone who matched the profile of the person they were looking for. But more than that, you'll hear the prosecution's own witnesses testify that they failed to find any evidence in today's case that ties Miss Becker to the scene of the crime. No fingerprints, no DNA, no eyewitnesses, nothing. So at the end of today's trial, my co-counsel Charlotte Combe will ask you to deliver a verdict that shows the prosecution's case simply has too many questions and not enough evidence. Thank you.
Your Honor, if I had been permitted to object during opening statement, I would have objected to this being an opening argument.
Does the defense have any response?
Your Honor, I did not make any argumentative statements over the course of my opening.
Okay, that's noted for the record. Thank you both. And for the benefit of the scoring panelists, even though I would note that preliminary matters are not scored, I did look into Rule 4.6. I don't believe that the defense violated any rules of the competition by having a different attorney addressing the preliminary matters than doing the opening statement for the benefit of the scoring panelists. And with that, let's move on to the evidence. Prosecution, you may call your first witness.
The prosecution calls Detective Markowitz to the stand.
Thank you. Detective, you've been sworn.
Hello, Ms. Markowitz. Please state your name and spell your last for the record.
Jordan Markowitz, Markowitz.
What do you do for a living?
I've been a Denver Police Department homicide detective for 13 years now, or for 7 years. I've been on the force for 13 years.
Do you have any specialized training?
Yes, I do. I have a cell phone technology and forensic data recovery certificate from the American Academy of Law Enforcement. The certification required 3 days of training and a certification exam.
What did you learn from this course?
I mainly learned about how to obtain and analyze cell phone tower records and cell tower data.
How do you utilize CDRs in your course of work?
I often use CDRs, or call detail records, to find information about how and when a crime was committed. These records track which cell tower a phone connects to, and any communications that go in or out of that cell phone at the time.
What is the significance of CDR records?
Well, oftentimes, police use these records to locate the perpetrator of a crime through their phone. As a phone typically connects to the nearest tower after a communication was made, I often use this in my investigations.
How many times have you used CDRs?
Well, I've used them in over 100 cases pertaining to cell phone records and over 50 cases involving cell tower data.
Your Honor, under Rule 702, I offer the witness as an expert in the fields of cell phone technology, forensic data recovery, and crime scene investigation. Her expertise, training, and education have been shown.
Can you repeat the 3 things you would like to enter her in as an expert?
Of course, Your Honor. Cell phone technology, forensic data recovery,
And crime scene investigation.
yes.
Any objection?
Yes, Your Honor. I specifically object to tendering Detective Markowitz as an expert in crime scene investigation, as the requirements for Rule 702 have not been met. Although Detective Markowitz did testify to her experience as a detective on the force, no foundation was laid that this had anything to do with crime scene investigation whatsoever.
I tend to agree. I heard a lot about cell phone data and experience with that, but can you lay a little more foundation with regards to crime scene investigation?
Yes, Your Honor. Why are you on this case today, Detective Markowitz?
I was called on this case to investigate the death of Mr. Mackenzie Brackman. I've investigated plenty of homicides and cases very similar to this.
When you were conducting this investigation, what did you concern yourself with?
I follow all the evidence and where it takes me. I concern myself with any leads and I always follow up with anything that I find.
Your Honor, is that enough foundation?
Experience counts as qualifications under Rule 702. So I suppose based on the testimony that she has investigated multiple homicides, I will admit her as an expert in crime scene investigation, cell phone technician, and forensic data recovery.
Is there a brief voir dire?
Would the defense like a voir dire?
No, Your Honor, I do not have a brief voir dire.
Thank you.
Would you recognize the defendant if you saw them today?
Yes, I would.
Can you identify the defendant in the court today?
Of course. It's the young lady over there with long brown hair and a black top.
Let the record reflect the witness properly identified the defendant.
So noted.
How did you become involved in this investigation?
On March 6th of 2020, I was assigned to investigate the death of Mr. Mackenzie Brackman, a criminal defense lawyer in Colorado. I was called to the scene after paramedics found him dead.
What did the scene look like when you arrived?
After I arrived at 2:20 p.m., I came in through the back door. I saw the body was face down just inside the residence. The murder weapon was next to the victim on the floor, and there was blood on the knife, the victim, and the floor at the scene.
Was there anything else you noticed?
Yes, the house was in disarray. A knife was missing from the knife block, and a knife drawer was open. What can I say? I'm a sharp detective.
I direct your attention to exhibits 1, 3, and 5. Do you see them?
Yes, I do.
Please identify them.
Exhibit 1 shows the victim lying on his floor, drenched in blood. You can also see a Ring video doorbell in this exhibit. Exhibit 3 shows the bloody knife wound. Lastly, Exhibit 5 is a picture of the murder weapon as it was found at the scene. This knife had blood on the handle, blade, and on the floor around it.
Are these accurate?
Yes, they are.
Your Honor, I move to admit exhibits 1, 3, and 5 into evidence as their authenticity and accuracy have been shown.
Objection?
Yes, Your Honor, I specifically object to the image of the murder weapon in regards to relevance, as it makes no fact more or less likely in today's case that Avery Becker was the one to have murdered Mr. Brackman.
I'm going to overrule that objection. I think the murder weapon in a murder case is relevant. Any other objections to exhibits 1, 3, and 5?
No, Your Honor.
Exhibits 1, 3, and 5 will be admitted.
Your Honor, permission for co-counsel to publish by screen share?
Yes.
This is exhibit 1.
Yes, it is.
Is this exhibit 2?
Yes. This is exhibit 3.
Exhibit 3, I'm sorry. Is this exhibit 5?
Yes, it is.
We ask that co-counsel may stop screen sharing now.
That's fine.
Now, I want to talk about your investigation. How did you start?
Well, I first checked the victim's ID, and I saw that he was wearing a mock trial shirt. When I investigated this further, I saw that his phone had a lot of mock trial related text messages and emails on it.
Then what did you do?
I followed up with the mock trial lead further. The victim coached at Colorado High School, so I obtained the contacts for all the members of the mock trial team. The first student I talked to was Alex Cifuentes, who provided some very valuable information in my investigation.
Valuable information?
Well, in some text messages between Alex and the defendant, Becker admits that she was going to trash the victim's house because the victim wouldn't let her back on the team after Becker vandalized the victim's car.
What did you do next?
When I was unable to get an interview with the defendant, I attempted to look at her phone, but it was allegedly lost. So instead, I obtained CDRs from the cell phone number. And then I made a diagram of the records that I found.
I direct your attention to Exhibit 16. Do you see it?
Yes, I do.
Please identify it.
This is the diagram that I made of the cell tower records. It shows the communications made on the phone and what cell towers the phone was connected to when these communications were received.
Is it accurate?
Yes.
Your Honor, I move to admit Exhibit 16 into evidence as its authenticity and accuracy have been shown.
Any objection?
Yes, Your Honor, I have 3 objections. First, best evidence in accordance with Rule 1002. Secondly, hearsay in accordance with Rule 801. And lastly, misleading the jury in accordance with Rule 403.
Can you expound on those, please?
Yes, Your Honor. Starting off with the best evidence objection, this diagram of the connections from the call detail records Detective Markowitz has are based off of call detail records she obtained from the defendant's cell service provider. Those call detail records would be the best evidence or the original to be used in court, and what they're providing today for evidence is only summarizing that. Secondly, with hearsay, I specifically object to Exhibit 16, the demarcation of Rock Creek Parkway from Avery Becker's home to Mr. Brackman's home as an out-of-court statement of the route they believe Avery Becker took the day of the murder. And lastly, with 403, I specifically object to misleading the jury. On Exhibit 16, there are red circles around each cell tower that tend to imply that those represent the range of each cell tower. If I may make an offer of proof, Professor Von Owens is going to later testify that each cell tower has a radius of 6 miles, and there's no demarcation for how wide the radius of the cell towers on Exhibit 16 are, so it has the possibility of misleading the jury as to the range of those cell towers.
Thank you. Response from the people.
Your Honor, I would like to say under Rule 1003 that copies and summaries are allowed, and that Detective Markowitz can address the radius of the direct of Van Owen. Okay, I'm sorry. That she can address the radius in her direct of Van Owen, and we ask that we can be able to do the same. And while this is copies, this is essential to what Detective Markowitz put on her investigation. Not only this, but it also shows the location and the route that the victim most likely took to the home, as it is important to show to the jury what a piece of Detective Markowitz's investigation looked like.
Is there a response to the hearsay objection?
Yes, Your Honor, but I also respond to...
Sorry, from the prosecution, is there a response to the hearsay objection?
I would like to say that this is not a statement put out of court, rather it is a picture that shows the path. It is offered for the truth of the matter asserted, but it's also for a party opponent. And it's not a statement, to be clear.
Okay. I'm prepared to rule on these objections. I agree that I think summaries are allowed as evidence. I'm going to overrule the best evidence objection with regards to that. I believe that computer data would not qualify as hearsay, and that's what it sounds like this evidence is. So I'm going to overrule the hearsay objection. With regards to the misleading of the jury objection pursuant to Rule 403, I think that's best addressed through any witnesses from the defense or cross-examination. So I'm going to overrule that part of the objection and admit Exhibit 16 at this time.
Your Honor, I ask that co-counsel share the exhibit so we can publish.
Yes.
May she mark on the exhibit?
Why don't you ask her a question first?
Thank you, Your Honor. Can you please describe the significance of this exhibit?
Of course. This exhibit shows the most likely path that the defendant took to get from their house to Mr. Brackman's house.
What do you find on these CDRs?
On these CDRs, you can see 3 communications that were made from Becker's phone.
Now, may I ask that co-counsel be allowed to mark on the exhibit?
Co-counsel will be marking on the exhibit, not the witness?
No, we felt that it would be better for co-counsel to do it so the witness can properly focus on her answer. But she can do it too if you'd like.
I think I would prefer the witness mark the exhibit if it's going to assist her testimony in this matter.
Where were the first two communications made?
Well, the first communication was made closer to the defendant's house. The second communication was made also close to Becker's house, and then the third communication was made closest to Brackman's house.
Was there any response to these?
There was no response. It was just crickets.
Where was the last communication made?
In the last communication, the phone was connected to the cell tower antenna that was closest to the victim's home. And this communication was also made around the time of the murder. Yet again, just crickets. After this, all communications suddenly stopped.
And can you, for the jury, draw what path you think Becker most likely took?
Of course. The defendant most likely went on this road, then down to Rock Creek Parkway, and continued on Rock Creek Parkway all the way down on this path until they got to the victim's house right there.
And what is the significance of the ring videos you previously mentioned?
The significance of these videos is that you can see the perpetrator in both of these videos during the time of the murder.
I direct your attention to exhibits 12 and 13. Do you see them?
Yes, I do.
Please identify them.
This is the footage that we pulled from the Ring video cameras and doorbell. Exhibit 12 shows a devil-masked perpetrator who is fully clothed going in through the back door, and this was taken around the time of the murder. Then Exhibit 13 shows the killer exiting through the front door after the crime.
Are these accurate?
Yes, they are.
Your Honor, I move to admit exhibits 12 and 13 into evidence as their authenticity and accuracy have been shown.
Any objection?
No objection, Your Honor.
Then exhibits 12 and 13 will be admitted.
Permission for me to publish over screen share to the jury.
Yes.
What exhibit is this?
This is Exhibit 12. This is Exhibit 13.
And from what you could see in these videos, who did you conclude was in them?
The defendant, Avery Becker.
Why?
Well, in my investigation, I concluded that from the text messages from Alex Cifuentes, the fact that Becker was kicked off the team and unable to get back on, the CDR records, the person's build in the videos, and the defendant's history of similar acts, the perpetrator seen in these videos was in fact the defendant.
Based on the evidence, what happened on March 6th?
On March 6th, the defendant, because of the loss of her mock trial dream, broke into the victim's house to trash it. The burglary went tragically wrong when the victim appeared armed with a knife. A struggle followed, and what started as a trashing of the home ended with a coach dead on the floor in a pool of blood.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Good afternoon, Detective.
Good afternoon.
I want to start off by talking about your investigation with Alex Cifuentes. You had a conversation with her, right?
I did.
She told you that she had some text messages.
Yes, she did.
And these text messages were one of the biggest breaks in your case.
Yes, they were.
So you had to interview her
I did.
at the police station,
Yes.
but she didn't bring her phone, did she?
No, he did not.
My apologies. So, just to clarify, you thought that was odd.
At the time, yes.
In fact, it might have been one of the only times you'd seen a teenager without their phone on them.
Yes. But now that I think about it, I don't think it's odd anymore because people act weird when they show up to police interviews. I understand.
But Detective, using your own words here, it might have been one of the only times you'd seen a teenager without their phone on them, correct?
Yes, that's correct.
Now, just to make this clear for the jury, you did not see any of the text messages Mr. Cifuentes told you about on his phone during that first interview, did you?
No, I did not. I just received screenshots.
Detective, you're getting a bit ahead of me. You did not see any of those text messages on Mr. Cifuentes' phone during that first interview, did you?
Objection, Your Honor. Asked and answered.
Overruled.
Detective, you never got to see Mr. Cifuentes' phone, did you?
No, I did not.
So you never got to see those text messages on Mr. Cifuentes' phone.
On his phone, no.
Instead, you just chose to trust the screenshots he sent you.
I did trust them, yes.
Now, on direct, you mentioned you have training in the Celebrite system, correct?
Yes, I do.
This is used to download information off of phones.
Yes, it is.
You said you've downloaded the contents of hundreds of phones before.
Yes, I have.
In this case, you downloaded information off of Mr. Brackman's phone.
I did.
And if you had obtained Mr. Cifuentes' phone, you would have been able to download those text messages off of it.
I could have been able to, yes.
All right, Detective, I now want to talk about Miss Becker's phone. You don't know who had her phone on March 6th of 2020, do you?
I know where her phone was, if that's what you're asking.
I'm sorry, Detective. I might not have been clear. You do not know who had Miss Becker's phone the day of the murder.
No, I do not.
Now, none of the texts from Miss Becker's phone were responded to.
They weren't. I'm not surprised, considering what she was doing at the time.
Detective, you gave me more of an answer than I was asking for. There was no responses to the texts on Miss Becker's phone, were there?
No, there were not.
The calls were not responded to?
No, the duration of the calls was too short.
Right. And they were all from Taylor Perkins.
That's correct.
Detective, you talked to Miss Becker's lawyers, didn't you?
I did.
They told you she lost her phone on March 5th.
That's what they told me, yes.
And just to clarify, this is a whole day before the murder ever even took place.
Yes.
They told you she was at the mall all day with Taylor Perkins looking for her phone.
That is what they said.
Detective, you did not look at all of the call detail records from Taylor Perkins' phone, did you?
No, I did not. I mostly looked into Becker's phone.
Right. And you did not download any data from Taylor Perkins' phone.
I did not.
All right. Now let's talk about those CDRs you mentioned on direct. So a cell phone connects to a cell tower that gives it the best connection, correct?
That's correct.
Now, most of the time, this is the nearest tower.
Most of the time, yes.
But if that nearest tower is busy, a cell phone will connect to a cell tower that is further away, right?
It can, yes. But in this case, it doesn't make very much sense for it to, because it only does that if the area that the cell phone is in is very busy.
Detective, I wasn't asking about your opinions in regards to today's case. If that nearest cell tower is busy, a cell phone is going to connect to a cell tower that is further away, correct?
It has a chance of it, yeah.
So sometimes a cell phone does not connect to the nearest cell tower.
Sometimes.
All right, I want to take your attention to Exhibit 16 now. Your Honor, permission for my trial tech to screen share what has been previously entered as Exhibit 16?
Yes.
All right, I want to take your attention to that middle cell tower. Now, an X mark is being placed on Rock Creek Parkway where Ms. Becker's phone may have been. Do you see that?
Yes, I do.
Now, if that middle cell tower is not busy, Ms. Becker's phone is going to connect to that cell tower, right?
Yeah, it could. It's not guaranteed to.
Exactly. Because if that middle cell tower is busy, Ms. Becker's cell phone is going to connect to a cell tower that is further away.
It could.
Ms. Becker's phone could have connected to that bottom cell tower.
Possibly.
Ms. Becker's phone could have connected to that top cell tower.
It could have connected to any of the cell towers that you're talking about.
Exactly. I want to shift gears now and talk about the range of these cell towers. Let's look at the bottom cell tower. Just to clarify, Mr. Brackman's home is near this cell tower, correct?
Yes, it is.
It's the one stamped with the green check mark?
Yes.
All right. Detective, an X mark is being placed near the bottom of Exhibit 16. Avery Becker's phone could have been over there and still would have connected to that bottommost cell tower, right?
It could have, but this path that I drew on this diagram that I made is most likely where the phone was.
Detective, I wasn't asking about the path on Rock Creek Parkway. Miss Becker's phone could have been there where the X mark is and still would have connected to that bottommost cell tower.
It could have, yes.
Miss Becker's phone could have been placed right there where the other X mark has been placed and still would have connected to that bottommost cell tower.
As we've established, yes, it could have.
So Miss Becker's phone could have been at multiple locations that were not the scene of the crime and still would have connected to that bottommost cell tower.
I suppose it could have.
Thank you. No further questions.
All right, if the defense will remove Exhibit 16, thank you. Redirect.
No, Your Honor, as I would like my co-counsel to have enough time to do their directs.
Okay, thank you. Does the prosecution have any further witnesses?
The prosecution calls Alex Cifuentes to the stand.
Thank you, Mr. Cifuentes, you've been sworn.
Hello, Mr. Cifuentes. Could you please state your name and spell your last for the record?
Alex Cifuentes, Sifuentes.
May I call you Alex?
You may.
Please tell the jury a bit about yourself.
I'm a senior at Colorado High School. Last year, when I was a junior, I was on the mock trial team that was coached by Mr. Brackman.
Please tell the jury more about mock trial.
I mean, I loved mock trial, and I was good at it. I was a great lawyer, and I was a pretty good witness, although it's strange in real life. I was on the team with two people here, Avery Becker, the defendant, and Taylor Perkins.
Do you personally know Avery Becker?
I do. It's still pretty difficult to take the stand against a teammate.
What's your relationship with Avery like?
Well, Avery was my best friend, and Avery is actually the one that convinced me to join mock trial. I liked Avery, but Coach Brackman did not seem to.
Objection, Your Honor, speculation.
Response?
Reasonably based on witnesses' perception. And my following question will address that.
I'm going to sustain the objection for now, strike the response, but you can try to lay some better foundation.
Alex, did you observe anything that supports that?
Well, yes, Avery constantly antagonized the coach. Brackman wanted a flawless team that was always as prepared as possible. Avery scoffed at preparation, and it caused problems.
Is that sufficient?
You can ask the question.
I did.
You can ask about his opinion now.
Okay. Let's move on, Alex. You said that Avery caused some problems in mock trial. What kind of problems do you mean?
Well, they argued every single practice. It was preposterous, quite frankly.
What did they argue about?
Well, Avery winged everything, and annoyingly, Avery was very good at it. Coach hated this. It caused 3 huge blowups. You know, I always joked that they'd kill each other, but I never expected fate could be so literal.
Could you tell the jury about the first blowup?
Sure. Well, the first one started because Avery was late. Again, for like the 1000th time. Brackman hit a boiling point, and his fury was beyond evident.
What happened next?
Well, Coach Brackman demoted Avery to B team. It was a major slap in the face because she was a senior.
Did Avery stay on the B team?
No, Avery wasn't on B team very long at all.
How come?
Well, Avery got Taylor, her other best friend, to quit. We need to fill the missing A team spot quickly. So after a 5-minute timeout, Avery was back on A team once again.
Was that the end of blowup number 1?
Yes, it was.
Okay. When does blowup number 2 start?
Well, soon after we went to regionals, and Avery winged it as always, and even managed to win Best Attorney Award, which is like the holy grail of mock trial. So I was a bit peeved.
Why?
Well, I work really, really hard on my materials, on my statements, and Avery just comes in, conjures greatness out of nothing, completely wraps the jury around her finger. But anyways, my anger was nothing compared to Brackman's.
Why was that?
Well, Brackman said that in the real world, in a real courtroom, just winging it would be malpractice. And of course, Avery got all huffy puffy and stormed out.
What happened after Avery stormed out of practice?
Well, this bleeds directly into blow-up number 3.
Okay. What happened next?
Well, what happened next was ridiculous, quite frankly. I saw Avery take a permanent marker, and then Avery wrote on Coach Brackman's car, Worst Attorney Award. Completely.
Objection, Your Honor. Improper character evidence, more prejudicial than probative, and relevance.
Response?
Yes.
Rule 404B2 states evidence may be admissible for proving motive, intent, and identity.
Okay, so that responds to the character evidence. What about the objection to more prejudicial than probative?
This helps prove motive.
I agree. Overruled the objection.
Okay. What was Brockman's reaction to Avery riding on his car?
Well, obviously, Brackman was extremely irate and kicked Avery off the team for good.
And what was Avery's reaction to this?
Well, Avery was extremely upset, and she was desperate to get back on the team. She sent me some texts.
Directing your attention to Exhibit 14, please identify it.
These are the texts that Avery sent me.
Are these accurate?
Yes.
Your Honor, the prosecution moves to admit Exhibit 14 into evidence. Its authenticity and accuracy have been shown.
Objection. Are there any objections?
Yes, Your Honor. Best evidence and hearsay.
Please explain.
Under Rule 1003, a duplicate is admissible unless its authenticity is in question, and in this case, it is. If I may make an offer of proof, Avery Becker is going to tell the court that she did not send those text messages, and in order for something to be authentic, there needs to be a propensity of evidence, or a preponderance rather, my apologies, of evidence demonstrating that it is authentic. And seeing as how Avery Becker claims that she did not write those texts, but Alex Cifuentes does, there is not a preponderance of evidence. And as there is no evidence that Avery Becker wrote these text messages fall under hearsay.
Response, Your Honor?
Yes.
This is an exception to the hearsay rule because it is a statement from a party opponent. And Mr. Cifuentes just testified to the authenticity of this exhibit. And there's no evidence yet to suggest these aren't authentic.
I'm going to overrule the objection and enter Exhibit 14.
Permission to publish via screen share.
Permission granted.
What is important in these text messages, Alex?
Well, they start off relatively normal, Avery asking for help, but later on it gets a bit strange.
How so?
Well, I told Avery that I don't really think the coach was going to let her back on the team after the car incident. And Avery responded with, and I quote, "Well, if he's still upset about the car, then he's going to be really upset when he sees what I do to his house."
What did Avery plan to do to Brackman's house?
Well, Avery planned on breaking in and trashing the place to really show him.
What was your response?
Well, I think I had a quite rational response. I thought it was a horrible idea, and I let Avery know.
Did Avery listen to you?
Of course not.
How do you know that?
Well, I saw the struggled relationship that Coach Brackman and Avery had. I saw Avery get angry and destroy the coach's car. I received texts where Avery threatened to break into the coach's house. Then somebody did break into my coach's house. Now my coach is dead. That's how I know.
Thank you, Alex. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Let me just quickly set up my camera.
That's fine.
Can the court see and hear me okay?
Yes.
All right, Mr. Cifuentes, I'm just going to ask you a few more clarifying questions. You and Avery Becker worked on the same mock trial team.
Yes, we did.
You think Avery's behavior left the team in a state of anxiety?
It did. It definitely left me in a state of anxiety.
You thought that Avery had a lackadaisical attitude?
Avery did.
So that's yes to my question.
Yes, it is.
You thought that Avery refused to work hard?
Yes, I do think that.
You don't think Avery won any awards because of any real talent?
I said that I believe Avery won on good looks alone. However, she had incredible improvisational talent.
I'm using your own words here, Mr. Cifuentes. You don't think Avery won any awards because of any real talent?
I said that.
But You worked hard on all of your mock trial material.
I definitely did. I loved what I did and I put my all into it.
Exactly. You put your all into it. You began your drafts as soon as Brackman assigned them.
Yes, I did. I wanted to be prepared.
You wanted to be so prepared that you revised them until they were perfect.
Yes, I did.
You spent considerable amounts of time memorizing the rules of evidence.
I did. I was really invested into the club.
You'd always practice your statements in front of the mirror or with your family.
Yes, I wanted to be perfect.
In fact, you worked so hard that it irked you whenever Avery made up things on the fly.
I mean, of course it did. Who wouldn't be irked if they put in a lot of effort and then somebody shows up and has put in no effort?
So that's a yes to my question.
Yes.
With Avery gone off the team, you thought that was for the best.
I did. I don't believe she brought much to the team in terms of effort.
I wasn't asking about what you thought Avery brought to the team. I was simply asking if you thought her absence was better for the team.
And I answered your question with a yes.
With Avery gone, you were excited for the larger role you were going to get.
Yes, but with Avery gone, we couldn't go to state.
But you were excited for the larger role you were going to get once she was kicked off.
I was.
Now I'd like to move on. Avery was kicked off from the team after the 2020 regional tournament.
Yes.
You claim that she sent you a series of texts after she was kicked off.
I do.
You claim that these texts state that she had intended to go to Brackman's house.
I do.
To vandalize it.
Yes.
After the murder of your coach, you got a call.
I did.
It was from a police detective.
It was.
Detective Markowitz.
Indeed.
You told Detective Markowitz about the text messages.
Not initially, but eventually I did.
And once you did tell him, it was decided you'd do an interview.
Yes.
You didn't bring your phone to the interview.
I did not. It's old, can't hold a charge, and I forgot due to the pressure.
Exactly. You forgot your phone, so you offered to bring it back.
Yes, and then Markowitz told me I can send screenshots.
Exactly. Detective Markowitz declined your offer and said screenshots were okay.
Yes, so I sent them.
You got a new phone around 3 months ago.
I did. My old one was very, very bad, and I need to communicate with other people.
Exactly. So you got a new phone and you have no idea where your old phone is.
Nope, we traded it in. It could be anywhere.
From the interview with Detective Markowitz until you traded the phone in, Detective Markowitz never asked to see your phone.
Nope, the detective did not.
Thank you, Mr. Cifuentes. No further questions.
Redirect?
No, Your Honor.
Thank you. Does the prosecution have any further witnesses?
Yes, Your Honor. The prosecution calls Kyle Kuzak to the stand.
Okay, Mr. Kuzak, you are still under oath.
Please state your name and spell your last for the record.
Kyle Kuzak, K-U-Z-A-K.
Mr. Kuzak, what do you do for a living?
I'm a crime scene reconstruction investigator. I'm not a police officer, but I'm a civilian consultant to the Denver Police Department.
How long have you been in that position?
For, 19 years this year. In fact, I'm in my third year of tenure with the city of Denver.
Does that require any certification?
It does. I was certified by the Colorado Bureau of Investigation.
Your Honor, I move to admit Mr. Kuzak as an expert witness in crime scene reconstruction, as his experience and certification qualifies him to give an expert opinion under Rule 702.
Any objection or voir dire?
No objection, Your Honor.
this witness will be admitted as an expert in crime scene investigation.
Mr. Kuzak, let's start by talking about your work in general. What is crime scene reconstruction?
Crime scene reconstruction is a process by which I, the investigator, take into account all the evidence collected at a crime scene, physical and witness evidence, and I use that evidence to recreate the actual events of what happened.
And can you briefly describe the process by which you do that?
Of course, I always approach my process in 5 steps: recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and the final reconstruction.
Now let's talk about this specific case. Can you describe that step of recognition of evidence as it pertains to this case?
Of course, I received the evidence collected by the Denver Police Department at the crime scene, including photographs, audio, and video, and I incorporated that into an organizational matrix.
And after completing this matrix, what did you do?
Well, then I move on to my second and third steps, which involves visiting the actual scene of a crime to get a feeling of the setting, of the layout, so I can know what the layout of the house looks like. And then I began to organize the evidence collected into evidentiary relationships.
And can you give an example of an evidentiary relationship in this case?
Of course. One of the first ones that I saw was between the evidence, the fact that the body and the knife were both found at the front door. Photographs, the second piece of evidence would be photographs of blood droplets leading from the kitchen to the front door. And finally, photographs of blood spatter across the walls and ceiling at that front door. You can link this into a clear chronology that Brackman was stabbed in the kitchen, he moved himself to the front door, and that's where the knife was removed, creating that splatter.
And what's the next step you take after examining those evidentiary relationships?
Well, then I move on to my hypothesis and testing, my final reconstruction, where I start to create event segments, which are larger, chronologically placed actions.
And what prominent event segments do you see in this case?
Well, there were 3 important event segments: the ring system videos, the scuff marks at the back door, and the journey of the knife.
You described earlier your 5-step process for us. Through your process in this case, what did you conclude from the evidence?
Well, from my process, connecting all of these event segments together, I concluded that the perpetrator, Avery Becker, approached the front door of the residence, tried the handle, found it locked, and wrapped around the house to the back.
And what happened next?
Well, unbeknownst to Avery, Brackman was alerted to her presence and scrambled to find a defensive weapon, settling on a knife from his own kitchen, grabbing a knife out of the knife block in his own kitchen.
And then what?
Well, the perpetrator, Avery, with this devilish mask on, entered through the back door, and Brackman was ready with the knife, and they engaged in this close combat, as evidenced by scuff marks found on the ground.
And what happened during that combat?
Well, this is where Avery wrestles the knife away from Brackman's grip, and in a moment of heated passion, stabs Brackman in the back in that combat. Avery then flees. Brackman tries to follow, but upon reaching the front door, pulls the knife out of his own back and falls to the ground, and likely dead before he hit the ground.
Thank you, Mr. Kuzak. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Just allow me a moment to prepare my space. So, Mr. Kuzak, let's just talk a little bit about the evidence you reviewed during your investigation.
Of course.
Now, you would agree with me when I said that, well, your investigation was dangerously incomplete.
I would not agree with you, actually, on that. That's not true.
Well, let's talk about this a little bit, because before coming to trial today, you prepared a matrix, correct?
Of course.
And you used this matrix over the course of your investigation.
Yes, I do. I elaborate on it and add to it.
And this has been identified as Exhibit 17, correct?
That's true.
Now,
the matrix is part of Exhibit 17, not the entire thing.
Exhibit this is a fair and accurate representation of your matrix, correct?
Only the first page and the second page of Exhibit of Exhibit 17 are my matrix.
Okay, so Your Honor, at this point, the defense moves to admit Exhibit 17 into evidence.
Objection?
No objection, Your Honor, as long as opposing counsel may show all of Exhibit 17 and not just the matrix.
Exhibit 17 is being admitted in its totality. Is that correct, defense counsel?
Yes, Your Honor.
Then it's admitted in its entirety and the jury will receive it as such.
Now, Your Honor, may my trial text screen share this exhibit to the witness and the jury?
Yes.
So first, I'd like to draw your attention to line 3. There's someone here identified as Ailes Cifuentes, correct?
The third row?
Yes.
Yes, I'm sorry, that must have been a typo. It's referring to Alex.
So this person, Alex Cifuentes, has been identified as suspect 2, correct?
Yes, that was introduced to me by the police, and I considered Alex a suspect, and I rejected that as a possibility.
Even though you considered them a suspect, this interview wasn't conducted until 3 months after the crime was committed, correct?
That may be true, but it should be noted that I do not conduct those interviews. But
Well,
that's true.
let's move up to line 1. There's someone here named Blair Rollins, correct?
Yes, there is.
And they've been identified as S3, correct?
Yes, Blair Rollins was also introduced to me as a suspect, and I also rejected that as a possibility.
Well, they've been identified here as S3 or subject 3, correct?
No, it would be suspect 3. Oh,
suspect 3. So
yes.
Suspect 3 is mentioned again in line 2.
Yes.
Mentioned again in line 3.
Yes, all of that referring to Blair Rollins.
They're even mentioned again into line 4.
Yes.
But this suspect, you noted right here, was unlocated, correct?
That's true.
So my my timekeeper can stop screen sharing at this point. So let's talk a little bit more about the other parts of your investigation.
Of course.
Now, you reviewed the police reports.
I did.
You visited the scene of the crime.
I did.
And you analyzed the evidence.
I did.
So you would also agree with me that the police didn't find any evidence tying Avery Becker to the scene of the crime, did they?
I would disagree with that. There is evidence tying Avery Becker to the scene of the crime. That evidence was found by the police, so I would disagree.
Well, let's talk about that a little bit. Now, if my timekeeper could screen share Exhibit 12 that has already been entered. Well, let's just take a few seconds and watch this video. Now, if we could pause a few seconds back. Now, this person is masked, correct?
They are.
And they're fully covered.
That's true too.
So you can't really see what this person's eye color is?
Because they're masked, yes.
You can't see their hair color?
Yes, they have a mask on.
You can't see their skin color?
That's true.
You can't even tell what gender this person is, can you?
Not to the untrained eye, but to professionals in investigating, you can analyze the person's build, the person's physique, and you can conclude their identity.
But you can't tell the gender of this person, can you?
I can. I analyzed this person and I concluded that it was Avery Becker, who was a female.
Well, let's talk a little bit about that analyzation. Now, if my timekeeper could stop screen sharing. Now, you reviewed the police reports.
Yes, as I stated earlier.
So you would agree with me that the police didn't find any evidence of Avery Becker at the crime scene?
No, I still disagree.
So they didn't find any fingerprints of Avery Becker?
No, they didn't find fingerprints and they didn't find DNA, but that video you showed was concluded to be Avery Becker. That's the evidence tying Avery Becker to the scene of the crime. Plus, and I didn't touch on this heavily in my testimony, but the cell phone evidence aided to that conclusion as well.
So the person you can't tell the eye color of, hair color of, gender, or skin color of is supposed to be Avery Becker, correct?
Objection, Your Honor, asked and answered.
Overruled.
It is Avery Becker.
But the police didn't find any fingerprints of Avery Becker at the scene of the crime?
Objection, asked and answered.
Sustained.
They didn't find any DNA of Avery Becker at the scene of the crime?
They didn't.
They didn't find any eyewitnesses who placed Avery Becker at the scene of the crime?
No, they didn't.
So there was no physical evidence of Avery Becker discovered at the crime scene, was there?
I would question your definition of physical evidence. This video ties Avery Becker to the scene of the crime as well as the cell phone data recovery records.
But once again, there were no fingerprints, no DNA,
Yes,
and no eyewitness.
that's true. If that's what physical evidence means, then you're correct.
Thank you. No further questions.
Redirect?
Yes, briefly, Your Honor. Mr. Kuzak, you spoke in cross about rejecting 2 suspects. Why did you do that?
Well, I was presented all of this evidence by the police, and I was presented these 2 suspects, or 3, Avery Becker, Alex Cifuentes, and Blair Rollins as suspects. And I took them all equally into account when I was creating my reconstruction. And I concluded on the basis of this video, on the basis of the cell phone tower data, and on the basis that there was no evidence indicating anyone else was near the scene of the crime who had motive. Through all of that analysis, I rejected Alex and Blair as suspects. They did not commit this crime.
You mentioned earlier you received evidence from the police. What did you do with that evidence?
Well, I took it into account and I considered it in my analysis, and I concluded in the end that this was Avery Becker and that this was not a premeditated sort of murder, that it was a burglary gone wrong. Avery Becker didn't go there to kill Mr. Brackman, but that's what happened.
Thank you, Mr. Kuzak. No further questions.
Your Honor, may I request a recross for purposes of impeachment?
I think you have 5 seconds left. I could be incorrect. Timekeepers can correct me if I'm wrong. So is that correct? 5 seconds? 4 seconds? 5 seconds. Okay. So I guess you can ask 1 question on recross.
Yes, Your Honor. 1 question is all that's necessary. So, Mr. Kuzak, in your statement, you do not ever say that you reject any suspects, correct?
The fact that I concluded on a suspect indicates I rejected all others.
You did not conclude a suspect.
No,
in your report,
you're
did you?
done. Any further witnesses from the prosecution?
No, Your Honor. The prosecution rests.
Okay. Thank you. Does the defense have any witnesses they would like to present?
Yes, Your Honor. The defense calls Blake Van Owen to the stand.
Okay. Thank you, Ms. Van Owen. You are still sworn.
Good afternoon. Could you please introduce yourself to the jury?
Good evening. My name is Blake Van Owen.
What do you do for a living, Miss Van Owen?
I'm a private investigator as well as a professor down at CU Denver.
What education do you have?
I received a master's degree in criminal justice back in 2014.
Do you have any experience in police investigation?
I do. I actually started out my career over at the Aurora Police Department and have then since worked extensively as a private investigator.
How many cases have you consulted in on as a private investigator?
Over 100 by this point. I've been working in that line for quite a while.
Have you testified in court before as an expert witness?
I have.
And what areas do you testify in?
I've testified in crime scene reconstruction 8 times, as well as cell tower analysis 5 times, and general police investigation 12 times.
Did you do anything in preparation for today's case?
Of course, I reviewed the exhibits put together by Detective Markowitz, as well as the crime scene reconstruction of Kyle Kuzak, and I actually did put together my own personal investigation for today.
Your Honor, at this time, the defense would like to tender Ms. Van Owen as an expert in crime scene reconstruction, general police procedure, and cell tower data analysis.
A brief voir dire, Your Honor.
Just a moment. All right. Crime scene investigation, police procedure, and cell phone tower analysis. Is that right?
Crime scene reconstruction.
Crime scene reconstruction. Okay. Yes, you may conduct a brief voir dire.
You have not provided a formal CV for the court.
I provided a documentation of my investigation for our purposes here today and detailed my experience and education for us.
I must have confused you. Let me restate my question. You have provided a resume.
I didn't see it necessary, so no, I did not provide one.
You've been in this line of work for 5 years.
Actually, quite a bit more than that. I've started out my career in 2005, 2006 at the Aurora Police Department.
Okay. And during this period of time, you're now a courtroom witness, a private eye, and you've been a professor before.
I am.
You've only been accepted as an expert in crime scene reconstruction 8 times.
Yes, 8 times. It's been quite a journey.
You've only been accepted as an expert in cell tower analysis 5 times.
Yes, in 5 different cases, my services were called upon to analyze some data.
When you've been an expert witness in over 100 cases.
I have. I testify in a range of different areas coming from my experience in law enforcement and my master's degree.
No objection to this witness being qualified as an expert so long as she stays within the scope of her expertise.
If there's any objection that she's testifying outside the scope of her expertise, I anticipate that you will object. Otherwise, she will be admitted as an expert in the fields of crime scene reconstruction, police procedure, and cell phone tower analysis.
Yes, Your Honor. Now, Ms. Van Owen, overall, what are your conclusions on the police's conduct during the case of Avery Becker?
I concluded that the police ran a haphazard and rather incomplete investigation that included the over-reliance on call detail records, as well as the failure to investigate key pieces of evidence in person, and finally, a failure to investigate all key suspects in this case.
Let's go through those one by one. First, could you tell the jury what errors the police made during the analysis of the cell phone records?
Well, generally, the police treated the call detail records as though they are the same thing as a GPS, which is very simply just not true. The way call detail records work, or that kind of data works, is they can see what cell phone tower a phone connected to. As long as a person's phone is within the range of that cell phone tower, which can be up to 7 miles as a radius, that phone can connect to that tower.
So just to be clear, phones can connect to towers that are further away.
Yes, they often try to connect to their closest tower, but in many circumstances do connect to a tower that is further away.
Are you aware of where Avery Becker was on the day Mr. Brackman was murdered?
I am. I'm aware that Avery Becker and Taylor Perkins were at the local mall and fry shack.
Your Honor, permission to screen share Exhibit 16 as it's already been admitted into evidence.
Yes, that's fine.
Just a moment. Now, Ms. Van Owen, what do the CDRs tell us about Avery Becker's location on the day Mr. Brackman was killed?
Well, if we look at the call detail records, we can see that Avery Becker's phone received several calls and texts from Taylor Perkins' phone. And those call detail records show us that the calls and texts made from Taylor Perkins' phone connected to the antenna in the center of the page, and specifically the second and third antennas, which covered that local mall, and the Fry Shack, both of which have just been stamped with X's.
And just to be clear, Ms. Van Owen, is this the mall?
Yes, it is.
And is this the Fry Shack?
Indeed.
Did Taylor Perkins' phone connect to these two antennae?
It did. Every time that Taylor Perkins' phone made a call or text to Avery Becker's phone, those were the antenna it connected to.
Thank you. Secondly, I'd like to discuss the way the police handled evidence in today's case. You mentioned that the police failed to get physical pieces of evidence. Could you elaborate more on that?
Yes, of course. I mean, specifically, they failed to get Alex Cifuentes' phone in front of them in person so that they could actually be able to try and authenticate the texts that Alex Cifuentes claimed Miss Becker sent, which of course she denies.
If the police didn't have Alex Cifuentes' phone, how were they able to analyze the text messages?
Well, the police relied upon...
Objection, speculation.
Response?
Yes, Your Honor. It's on the record that Miss Van Owen has looked through the police records and has looked over Detective Markowitz's investigation in this case, so she should be aware that the police department used text screenshots rather than the actual phone of Alex Cifuentes during their investigation, and she was present for the trial where Detective Markowitz mentioned it and Alex Cifuentes mentioned it.
Response?
I stand by my objection.
Objection overruled.
Do you need me to re-ask my question, Miss Van Owen?
Yes, please.
If the police didn't have Alex Cifuentes' phone in front of them, how were they able to investigate the text messages?
Well, the police relied upon screenshots, which I must admit would not be something I would do.
What's problematic about using screenshots?
Well, I mean, in this day and age, it would be very easy for someone to falsify or doctor a picture like that.
If the police had Alex Cifuentes' phone in front of them, would they have been able to authenticate the text messages?
Yes, absolutely. The police have a special technology exactly for that purpose. It's called Celebrite, and what it allows the police to do is download the contents of a phone and then look through it and see if something is real or not.
Did the police use Celebrite to analyze Alex Cifuentes' phone?
Unfortunately, no.
Finally, Ms. Van Owen, you mentioned that there were alternative suspects that were not investigated by the police department. During your partial investigation, why did you conclude that there were other suspects?
Well, I came across someone who had a very strong motive for committing the crimes, whose name is Blair Rollins.
What motive could Blair Rollins have had against Mackenzie Brackman?
Well, Blair Rollins' father, Jonathan Rollins, had been put on trial for murder. It was Mackenzie Brackman's job to defend Jonathan Rollins in court. Unfortunately, Mackenzie Brackman lost that case, resulting in Jonathan Rollins being sentenced to life in prison.
Was Blair Rollins present for his father's case?
Yes, indeed.
How does the case of Jonathan Rollins connect to the murder of Mackenzie Brackman?
Well, at the end of the whole trial and everything with Jonathan Rollins, Mr. Rollins shouted a threat at Mackenzie Brackman while Blair Rollins, his son, was in that courtroom.
Could Blair Rollins have heard his father's threat?
Definitely.
Did the police department investigate Blair Rollins?
No, they marked Blair Rollins as a potential suspect and then failed to even try to locate Blair Rollins, failed to even attempt to talk to Mr. Rollins, failed to do really anything at all.
Thank you, Ms. Van Owen. No further questions.
Cross-examination?
Yes, Your Honor. Professor Van Owen, you were with the Aurora Police Department.
I used to be, yes.
You worked there for 9 months before you left.
I did.
You say you were disillusioned with police work.
Yes, with some of the more unethical tactics.
Because of the tactics and techniques.
Yes, some of them I just disagreed with, so I left to try and do better things with my life.
You left because of an incident.
Yes, an incident involving those tactics. After I became aware of just how unethical they were, I dedicated my life to doing better and to learning so I would not make that mistake ever again.
You think of yourself as a check on the power of the police.
I do.
Now let's talk about your fees. You make a decent living.
I do.
You charge $225 per hour of research.
I do. That's pretty average in my
And
field.
$450 per hour.
Objection, Your Honor. Relevance and more prejudicial than probative. May I be heard?
Briefly.
Thank you. Ms. Van Owen's payment for participating in today's trial does not make the fact that Avery Becker could have killed Mr. Brackman more or less likely, thus it's irrelevant to today's case.
Response?
Briefly.
Professor Van Owen's fees tie directly into her bias and credibility.
I do believe the jury could consider it with regards to bias or motive to testify, so I will allow the question overruled.
You have only ever testified as a defense witness.
The prosecution's just never asked, so I haven't been able to do that, no.
Next, you know both of the prosecution experts.
I do.
You never went to the crime scene yourself.
That was unneeded. My job is simply to analyze what the police have done, not to do it myself.
You only reviewed police documents.
Yes.
You agree with CSR expert that Kuzak that the evidence points to an intruder who broke into the home.
Yes, I do.
It is possible the scuff marks by the back door were made in a struggle.
I didn't see any evidence of that in my analysis of the case. So while possible, I don't think there's anything to back up that claim.
And there's no evidence disproving that claim.
That's sort of the problem here, ma'am.
Moving on, Avery Becker was absent from school the day of the murder.
Yes.
Let's move on to cell tower records. You heard Detective Markowitz testify that Avery Becker's phone connected to the cell tower closest to the victim's house.
I did hear that, yes.
During the time and day of the murder.
Yes, as I've said, though, that does not in any way tell us that Avery Becker was at the crime scene. First of all,
criticize Detective Markowitz's use of the CDRs.
I did. I thought they were not analyzed in a way that was productive in this case.
You used those same CDRs.
I used them to show the connections of Taylor Perkins' phone, not to pinpoint an exact location at any one point in time.
You pinpoint Taylor at the mall in Freishack.
I believe the evidence suggests they were in that general location, as all the connections were centralized to that one small area.
You did not obtain cell tower records of your own.
No, that's not my job, ma'am.
Yet, in your statement, you admit you should have done so.
I admit that it would have been possible for me to do so, and that perhaps I could have. But again, ma'am, that's not my job. That's Detective Markowitz's job.
Let's talk about text messages. You say screenshots can be doctored.
Yes.
There's nothing in your statement to show they actually were.
Again, ma'am, not my job. My job was to analyze the job done by the police and their errors. In this
But
case,
it's your statement.
The screenshots, which I did point out in my statement.
You admit a conspiracy between Alex and Blair seems a bit too cloak and dagger.
I'm not sure those were exact words. They may have been, ma'am. My suggestion again was the police's lack of investigation into Blair Rollins.
You, in your statement, you use the exact words "to cloak and dagger" to refer to a conspiracy between Alex and Blair Rollins.
I do, ma'am, but I do say the motive of Blair Rollins definitely needed to be investigated in this case.
Let's talk about Blair Rollins. You offer Rollins as an alternate suspect.
I do.
You, in your statement, you say Rollins was absent from school on the day of the murder.
Yes, that along with the motive led me to believe there was a lack of investigation.
You say Rollins was absent based on school records you reviewed.
I did.
School records you did not provide in court today.
I didn't deem that necessary, ma'am, so no.
It's your assertion that Blair was missing.
Blair was missing, ma'am.
Next, you say Blair's father threatened the victim.
That's correct.
Nowhere in your statement do you say Blair ever threatened the victim.
No, ma'am. Blair's father threatened the victim while Blair Rollins was present at the emotional trial.
You assume like father, like son.
I'm not sure I would phrase it that way. Well, perhaps I would in some ways, that once the threat was made, Blair Rollins decided to take action on that. But again, ma'am, the point was the police never investigated that. And it was a very suspect set of occurrences that I believe in every case should have been investigated.
Thank you, Professor Van Owen. No further questions.
Redirect?
Yes, Your Honor. Ms. Van Owen, does the fact that you're being paid for your time today affect any of the conclusions that you're making?
Absolutely not. Never.
Do you have a burden to bring any evidence to today's trial?
I do not. My only job is to look at the job done by the police.
Do you have a burden to prove anything today?
Objection, not in the scope of my cross-examination.
I believe it is overruled.
Let me re-ask my question. Do you have a burden to prove anything today, Ms. Van Owen?
No, only to raise points and errors that were made in the case that could lead to a different verdict than the police want.
Thank you. No further questions.
Does the defense have any further witnesses?
Yes, Your Honor. The defense calls Taylor Perkins to the stand.
Okay. Thank you, Ms. Perkins. You've previously been sworn. You're still under oath.
So, Ms. Perkins, could you please introduce yourself to the jury?
Well, hi, my name is Taylor Perkins.
And what do you do for a living, Ms. Perkins?
Well, I'm currently a freshman at CU. I'm a theater major.
And where did you go to school last year?
Well, last year I went to Colorado High School, CHS.
And do you know the defendant in today's case, Avery Becker?
I do. She's my best friend.
Do you know the victim in today's case, Mackenzie Brackman?
Yeah, he was my mock trial coach.
Now, Ms. Perkins, do you know whether Mackenzie Brackman was killed by Avery Becker?
I do. I was with Avery the whole day.
So did she?
Absolutely not, no.
Let's back up a little bit and talk about your relationship with Avery. What was it like?
Really good. I mean, we're best friends and we did lots of activities together.
Like what?
Well, mock trial was probably her favorite and mine was musical theater. We also did Keys Club and just school activities and we hung out all the time.
So could you explain to the jury what this mock trial program is?
Of course. So it's really similar to musical theater, except usually there's no dancing or singing. Said there was at one time, but generally there's no singing. And we even get to wear costumes, except our costumes are suits.
So were you able to observe the relationship between Ms. Becker and Mr. Brackman?
I was.
Objection, Your Honor. Leading.
I don't believe it was. Objection overruled.
Ms. Perkins, would you like me to re-ask the question?
Sure.
were you able to observe the relationship between Mr. Brackman and Miss Becker?
I was, yeah.
And what was it like?
Tense is probably the best way to put it.
What do you mean?
Well, Avery had a tendency to be a little bit unprepared, but she was still by far the best on the team. I mean, she was so talented. But I think her being unprepared could upset Coach Brackman at times.
So did anything ever come of this?
Yeah, I think it was about a month before regionals last year. Avery came in probably the most unprepared I'd ever seen her. And it's usually not obvious, but it was kind of obvious that time. And don't get me wrong, she was still like flawless. She's just that good. But I think Coach Brackman he got a little upset and demoted her to B team.
So what did you decide to do?
Quite frankly, I didn't love mock trial. I mean, musical theater was way more important to me, and I'd just been cast as Adelaide, the lead in Guys and Dolls. So I had that on my plate, and I didn't have any friends in mock trial, and I didn't really want to be in it if I didn't have friends. So I quit in solidarity with Avery.
Now, do you know what happened in the mock trial program after you left?
Yeah, I do.
Were Avery and Coach Brackman ever able to get along?
Not that I know of. No.
What happened?
Well, I guess Coach got mad at Avery again and kicked her off the team.
Now, were you aware of what Avery did after this?
I am, yes.
What did she do?
Well, she loved mock trial the way that I love musical theater, and she it was her life, so she did everything she could to get back onto it.
So what did she do?
Well, she tried apologizing to Coach multiple times, but he kind of ignored her, I guess. And she even offered to get a summer job to help pay for the damages to his car.
Now, let's move forward a bit to the day of March 6th, the day of the murder. Now, what happened this day?
Well, Avery and I usually ride to school together, and I was texting her and she wasn't responding.
Did you figure out why she wasn't responding?
Yeah, when she came to pick me up, I talked to her about it, and she realized that she was missing her phone, that she'd lost it.
So what did you decide to do?
We didn't have all that much going on in school. Tech week for musical theater was the next week, so I didn't have that going on. And we'd taken our lit quiz earlier in the week, so we were pretty much set school-wise. So we spent the whole day looking for her phone, just completely retracing our steps.
So where did you go?
We completely retraced our steps from the day before. So you spent a good chunk of time at the mall looking for her phone, and then we also checked the Fry Shack.
Now, were you with Avery between, say, noon and 2 that day?
Yeah, we were probably either at the mall or heading towards the Fry Shack.
Did she ever leave your side during this point?
Absolutely not, no.
Did she ever leave your side that day?
No.
So did Avery kill Mackenzie Brackman?
Absolutely not, no.
Thank you. No further questions.
Cross-examination?
Yes, Your Honor. Ms. Perkins, let's begin with your time on the mock trial team. You were on the mock trial team?
I was, yes.
Coach Brackman was your coach?
He was.
You thought he was a mediocre coach.
I did. I didn't have a super high opinion for him. I thought he could make some poor choices for our team.
You would have rather spent time hanging out with friends than going to mock trial.
Yeah.
Objection, relevance.
Response?
Your Honor, I am just laying foundation that for my next question of their relationship with Avery Becker. And so I'm just trying to lay foundation for the next question.
I'll allow it for now. The prosecution may re-object if it keeps going.
You only went to mock trial because of the defendant, Avery Becker.
Well, she's the whole reason I joined mock trial, not the only reason I went, just the reason I joined.
It's your sworn statement today that you did not go to mock trial for the defendant, Avery Becker.
Well, Avery was a part of it, but she wasn't the whole.
Because Coach Brackman was always giving Avery a hard time about something.
He could. I thought it was pretty mean of him.
Whether or not this be Avery not coming to practice prepared.
I mean, she could come to practice a little bit unprepared, but she was still by far the best on the team.
But Coach Brackman was heated because she didn't come prepared.
He could be at times, yeah.
Or because Avery was a little late to practice.
Yeah, again, but she was still by far the best on the team.
So Coach Brackman often would get heated with Avery because she was a little late to practice.
Yeah, sometimes.
That drove Brackman crazy.
I'm not sure that it drove him crazy. I think it upset him a little bit.
So it's your sworn statement today that this did not drive Brackman crazy?
Oh, I'm not saying that it didn't drive him crazy. I think it upset him a little bit.
In fact, in your statement, you call this a feud.
I would say it was a feud, but I didn't entertain it. I thought it was kind of funny, honestly.
The feud bothered Avery.
I think it could bother her, yeah. She would get upset at the things he said. I mean, I would get upset too.
Enough that Avery would often pull pranks on the victim.
She could, yeah.
Now, let's talk about the practice a month before regionals. You were there.
I was.
Avery came to that practice the most unprepared you had ever seen Avery.
Yeah, but like I said, she still performed flawlessly.
This made Coach Brackman heated.
I thought it did, yeah.
So he moved her from A team to B team.
Yeah, I thought it was kind of unfair. I mean, honestly, I didn't think that that our A team could make it to state without her.
So you quit mock trial altogether.
Well, yeah, because I didn't love mock trial, and I didn't want to be on it if my friends weren't on it.
Is that a yes?
Yes, that in addition to musical theater and the friend thing.
To support your friend Avery.
Yeah, in support of her, not because of her.
Let's talk about the practice after regionals. You were not there to see the blow-up between Brackman and Avery.
I wasn't, but Avery told me all.
Coach Brackman was giving Avery a hard time.
That's what she told me, yeah.
This made Avery upset.
That's also what she told me. I mean, she said that she didn't deserve her awards.
So Avery stormed out of practice.
That's what she told me.
Objection.
On the way out, Avery wrote...
Response to hearsay.
This is not offered for the truth of the matter asserted. On top of this, it's said by... This goes directly to motivation, and it's for an opposing party.
Response?
Your Honor, they are using the prosecution is using this out-of-court statement for the truth of the matter asserted.
I do believe it's an admission by a party opponent, so I'll overrule the objection.
So Avery stormed out of practice.
Again, that's what she told me.
On the way out, Avery wrote Worst Attorney Award on the hood of Coach Brackman's Porsche.
Again, that's what she told me, but she told me she also thought it was dry erase marker.
So Brackman kicked Avery off the team.
Yeah, I think so.
Now let's talk about how Avery tried to get back on the team after Avery was kicked off. You and Avery talked about ways Avery could get back on the team?
Yeah, I mean, I wanted to support her. She loved mock trial.
You believe Avery texted everyone on the team. You think even Alex Cifuentes?
I think she did, but again, I don't know. I'm not Avery.
Is that a yes?
Yes.
Now let's talk about the night of March 5th. Avery got upset?
Yeah, she did.
She stormed off to the bathroom.
Yeah, because Alex was being really insincere and...
Avery's phone was still on the table, you think?
I think so, yeah. That's my recollection anyway.
This is how upset Avery was.
Yeah, I mean, I'd be pretty upset too.
Because Avery's phone was like their third kidney.
It was, but she was really upset.
Now, directing your attention to the day of the crime, Avery lost her phone.
Yeah, she did.
You ended up ditching school to find it.
Yeah, we spent the whole day looking for it. I mean, I completely voluntarily did. She didn't make me ditch, if that's what you're implying.
Lastly, I want to go back to your relationship with Avery. You testified you only went to mock trial because of Avery.
Yeah, that's why I started going to mock trial.
You testified you quit the team for Avery.
Not for Avery, more because I didn't want to be on it, and I guess that was just a bonus that she got back on.
You testified you tried to help Avery get back on the team.
I did.
You testified you ditched school to help Avery find her phone that was allegedly lost.
Again, that was completely voluntary. She did not make me do that. I just did that because she's my best friend, and
Thank you, Miss Becker. Now you're here providing an alibi for Avery.
I am, but our stories match completely.
Thank you, Miss Becker. Your best friend.
Yeah, but I would never cover up.
No further questions, Your Honor.
Redirect.
Yes, Your Honor. Now, Miss Perkins, would you ever lie in a court of law?
Absolutely not. I mean, Avery's my best friend, but I would never cover a murder for her or anyone, let alone.
And what was your relationship with Avery like?
I mean, we were really close. She's my best friend. I mean, she supported me with musical theater and mock trial, and she just adored mock trial.
So did she ever have to threaten you or coerce you into doing any of this?
Absolutely not. No, I mean, me quitting the team was for musical theater, and it was just the added bonus of Avery getting back on the team. And I ditched school because I wanted to help her.
Thank you. No further questions.
Thank you. Does the defense have any further witnesses?
Yes, Your Honor, the defense calls Avery Becker to the stand.
Okay. Make sure we have the prosecution attorney. There she is. All right, Ms. Becker, you've previously been sworn and you are still under oath. You may proceed.
Good evening. Please introduce yourself.
Good evening. My name is Avery Becker.
Now, Ms. Becker, you're here today because you've been charged with murdering Mackenzie Brackman. Did you kill Mr. Brackman?
No, I did not.
We're going to talk about Mr. Brackman more in a moment, but Ms. Becker, what does your life look like now?
Well, currently, because of this whole mess, it's not the greatest. But I really can't wait for my future plans. I'm excited to go to college. I'm really hopeful that I can continue my mock trial
Objection,
journey.
Your Honor. This is irrelevant.
Response?
Yes, Your Honor, I'm laying foundation for who the defendant of this trial is. We'll keep it very brief.
I agree, it's probably not relevant, but I will give you a little leeway. Objection overruled.
All right, Ms. Becker, Taylor Perkins earlier explained what mock trial is. Did you enjoy the activity?
Oh, absolutely. It was probably my favorite extracurricular activity. It was something that came naturally to me. I was really good at it, which helped with enjoying it.
Who was your coach?
Mr. Mackenzie Brackman was my coach for all 4 years of high school.
What was your relationship like with Mr. Brackman?
At the time, I will admit that it was not the greatest. We disagreed on a lot of things involving mock trial, and that created tension.
All right, Ms. Becker, I now want to talk about the day of the murder, March 6th of 2020. Where were you?
I was not at school that day. I had actually made the decision to ditch school so that I could go to the mall with my best friend, Taylor. We were actually looking for something there.
What were you looking for?
My phone. It had gone missing the day before. I had it when I was at the Fry Shack, and then I went home and I ate dinner and I went to bed. And when I woke up the next morning, it was gone. I could not find it anywhere.
Were you ever able to find your phone?
Taylor and we looked everywhere, and Taylor called my phone several times, but we never found it.
Let's talk about Mr. Brackman more. Earlier, you mentioned you were on his mock trial team. Were you successful in this program?
I'd say it's pretty successful. By the time I was a senior, I had made it to the A team, which is the top mock trial team, and I even won a couple of awards at our regional competition.
What awards did you win?
I won best.
I'd once again argue that this is irrelevant.
I will sustain that objection.
So you mentioned that you won some awards. How did Mr. Brackman react to you winning them?
Well, after I won the awards, we were at practice a couple days later, and we got into an argument about them. He said some really cruel things to me.
What did he say?
He told me that I didn't deserve my awards. He told me that I'd only earned them because of my good looks and charm, which I thought was a really mean thing for him as a coach to be saying to me, his student. They were really hurtful. And because of those comments, I did something that I regret.
What did you do?
Well, after we had finished arguing, I stormed out of practice. And I had what I thought was a dry erase marker in my hand. And I took that marker and I wrote on his car. I didn't find out till later that the marker wasn't dry erase, it was permanent.
Did Mr. Brackman find out?
He did. He had followed me into the parking lot. And once he saw what I had done, he made the decision then and there to kick me off the mock trial team permanently, which I understand now.
Did you try to apologize to Mr. Brackman?
Oh my gosh, of course I did. I felt horrible and ashamed of my actions. I mean, I knew that no matter what he had said, I should not have done that. So I went the very next day in person to apologize, but he didn't want to see me. His secretary wouldn't let me in.
Were you ever able to apologize?
I did end up texting him. I texted him an apology since I couldn't do it face to face. And I even offered to get a summer job just to help pay to repaint his car.
Miss Becker, why did you want to apologize to Mr. Brackman so much?
I knew that what I had done was awful, and I wanted him to know how sorry I was for my actions.
Let's talk about some other people involved in today's case. Did you hear Alex Cifuentes testify earlier today?
Yes, I did.
Now, Mr. Cifuentes claims he got a text for you asking for help to get back on the mock trial team after you were kicked off. Did you ever write that?
No, I did not. If I was going to get back on the team, I wanted to earn Mr. Brackman's forgiveness first.
Mr. Cifuentes claims you also sent him a text saying you were going to wreck Mr. Brackman's home. Did you write that?
Absolutely not. I don't even know where Mr. Brackman lives.
Miss Becker, did you see the Ring videos brought up earlier today?
Yes, I did.
Are you the person in the Ring video?
No. I mean, I understand that that person and I have a similar-ish build, but a lot of people have that body type, not just me.
Miss Becker, were you at Mr. Brackman's home the day of the murder?
No, I was at the mall all day with Taylor.
Miss Becker, did you want to hurt Mr. Brackman?
Absolutely not. In the days before his death, I was still doing all that I could to earn his forgiveness.
Thank you. No further questions.
Cross-examination?
Yes, Your Honor. Hello, Ms. Becker. I'll begin by asking you about your relationship with Mr. Brackman. Do you understand?
Yes.
All right. So you were on the Colorado High School mock trial team for all 4 years of high school.
Yes, I was.
And you and Taylor Perkins saw mock trial as a way to hang out.
We did. We enjoyed doing that along with other activities.
But when your coach, Mr. Brackman, caught you not paying attention, he was unhappy.
He definitely liked a focus team.
So you testified earlier that Coach Brackman and yourself did not have a good relationship.
We did not. I will honestly admit that, yes.
In fact, he said you were lazy.
He did.
And he said you didn't put in the work.
He did say that, yeah.
In your statement, you claim you think he hated you.
I know that I think that his opinion of me was definitely not very high.
That's a yes.
It is, yes.
You'd argue at almost every single practice.
Like I said, our relationship was not great.
When Brackman moved you down to the B team the first time, he was moving you away from your best friend.
Yeah, he was, but he had other reasons for doing that. He didn't like how I was operating within the A team.
Right, but you then tried everything to get back on A team.
I mean, like I said, I'm really good at mock trial. I know that. So I knew that the A team was where I needed to be, not the B team.
That's a yes. You tried everything.
I did, yes.
When Taylor Perkins quit the team, that worked out pretty well for you.
Well, once Taylor quit, a spot opened up and Mr. Brackman needed somebody to fill it.
So that's a yes.
It is.
Moving further along the timeline, after the regional competition, Mr. Brackman didn't congratulate you on your performance.
We got into an argument about what had occurred at regionals.
That's a yes. He didn't congratulate you.
No, he did not.
All right. And you were angry.
It did frustrate me. I did not like his reaction.
In fact, so angry that you threw insults at your coach.
We were arguing. I mean, I think insults were exchanged on both sides.
That's a yes. You threw insults.
I did.
In your statement, you call Brackman a lousy attorney.
I did not think highly of his skills as attorney.
That's a yes. You call Brackman a lousy attorney.
I did say that, yes.
Let's move along to talking about the incident after regionals with the car. When you left at the practice after regionals, you had a permanent marker in your hand.
I 100% thought it was dry erase. I thought that if I wrote on the car, it would just come right off. And when I found out it was permanent, I was devastated and ashamed of myself.
I'm sorry, that wasn't my question. The marker in your hand was permanent.
That's not what I thought it was, but yes, it was permanent.
I'm not asking for your opinion on what you thought it was in the moment. I'm asking that marker was permanent, yes?
Yes, it was.
And you were angry.
I was frustrated, yes.
When you used that marker to write on your coach's car, you were dismissed from the mock trial team.
Permanently, yes.
And after that, you went home.
I did.
And you talked to your mother.
Yes, I did.
But you told her that Brackman got on you for no good reason that night.
I was ashamed of my actions, and I didn't want her to know about them.
And you were even angrier than before.
I was definitely angry, yes.
And you didn't tell your mother what you had done to the car.
Like I said, I was ashamed of what I had done, and I didn't want her to know.
But what you did tell her is that you'd get back at Mr. Brackman if it was the last thing you did.
I did say that, but I did not mean it in any way.
Moving along, take a look at Exhibit 14. You should have it as it was published. These are texts with your name at the top of the conversation.
Objection, lack of personal knowledge.
Response?
Your Honor, these have been previously handed to the witness. I'm not asking her opinion or her judgment about these texts, but I'll rather just be talking about the exact content of the text.
Response?
Yes, Your Honor. Ms. Becker just testified that she had not seen any of the text messages in Exhibit 14 whatsoever before today's trial. So she can't testify in them because she has no personal knowledge of them whatsoever.
May I respond, Your Honor?
Last response, yes.
I'm once again not asking about the witness's personal knowledge. These are shown in court today, which means that the witness is able to see them, and that's all that matters for my line of questioning.
I will allow you to ask the question, whether the witness has personal knowledge or not. I will allow her to answer that.
All right, Ms. Becker, these are texts with your name at the top of the conversation.
Yeah, my name's up there, but I never sent them.
Read silently with me as I read aloud the first text. Hey, Alex, it's Avery. And then the next text. I'm sure you're aware that I got kicked off the team. I'm pretty desperate to get back on. You did, in fact, get kicked off of the team.
Yes, I did.
And you were, in fact, desperate to get back on.
I did want to be on the mock trial team, but I did not send those texts.
But that's a yes, you were desperate to get back on the team.
Yes, I was.
Keep reading with me as I continue to the third green text. Come on, please. It's really important to me. Mock trial was really important to you.
Sure, it was a super important part of my life, but I didn't send that text.
A while ago, you heard Taylor Perkins testify she thinks you asked Alex for help getting back on the team.
I did hear that, yes.
And a while ago, you also heard Alex Cifuentes testify that you asked Alex for help getting back on the team.
Yes, I heard that.
Nothing further, Your Honor.
Redirect?
Yes, Your Honor. All right, Ms. Becker, I want to start off with those text messages you were asked about on cross-examination. Would you go to Mr. Cifuentes to ask for help to get back on the team?
I would not. I didn't send those texts. Honestly, I was desperate to get back on the team, but I was not going to go through Alex to do that.
You were also asked about some things you said to your mother after you were kicked off the team. You said that you'd get back at Brackman. Did you actually mean that you were going to get back at Brackman?
No, absolutely not. I will admit to saying that. I said that in my anger, but it was never something that I meant or was going to follow up on.
And lastly, Ms. Becker, did you want to get revenge?
I didn't. Like I said, in Mr. Brackman's last days, I was still apologizing for the incident with his car.
Thank you. No further questions.
Thank you. Does the defense have any further witnesses?
No, Your Honor, the defense rests at this time.
Okay. And is the prosecution ready for closing arguments?
Yes, Your Honor. But before I begin, may I reserve the balance of my time for rebuttal?
You may. You may proceed.
Your Honor, opposing counsel, and members of the jury, Avery dealt with the devil and got burned. Angry at her coach, Avery broke into his home to trash it. When her coach was, to her surprise, armed, a struggle ensued and Avery killed her coach. The defense has claimed that there are too many questions and not enough evidence, but after the presentation of the evidence, we see this simply isn't true. Let's examine some of that evidence now, starting with the prosecution witnesses. First, you heard the words of Detective Jordan Markowitz, an expert who, based on her evaluation of the evidence, drew the conclusion that it was Avery who intruded into Mr. Brackman's home. But next, Alex Cifuentes, a friend of Avery's, testified to Avery's frequent behavior through words and actions. And finally, you heard from Kyle Kuzak, an expert witness. From his testimony, we ask you to remember that he, as an expert, solidifies and thus proves the event sequence that Detective Markowitz puts forth. Most importantly, he, as an expert, knows Avery was, once again, the intruder. 3 witnesses also testified for the defense, which I'll go over now. You first heard from Blake Van Owen, where the truth came out. Van Owen's involvement in the system may be lengthy, but she has professed bias against the police department. As a result of this resentment, Van Owen only ever testifies for the defense as a paid witness. That fact alone should discredit Van Owen. But moreover, Blake Van Owen was never at the initial crime scene, the way that both experts who testified for the prosecution were. Her investigation is thus neither comprehensive nor reliable. You then heard from Taylor Perkins, who only further confirmed that Avery was angry. But lastly, you heard from Avery herself. And she, before you today, verbally confirmed her patterns of anger. Avery admitted she was angry. She acted upon her own personal hatred for Brackman 3 times. When she vandalized his car, when she broke into his home, and finally, when she stabbed her coach in the back. I implore you to remember the words that Avery told her own mother, that she would get back at Mr. Brackman if it was the last thing she did. Every single thing that Avery said she would do, both verbally and in text messages, she did. But she went even further than that. The evidence shows that a burglary went tragically wrong, as the victim appeared armed with a knife. And Avery, after a struggle, managed to get a hold of the knife and stabbed the victim. Thus, members of the jury, the defendant before you today is being charged with second-degree burglary of a dwelling and murder in the first degree. These are not light charges. These are significant and they are impactful, but there is a dead man and an evidence trail leading directly to Avery Becker, which has been confirmed by not just one witness who is an expert, but 2. Jury instruction number 2 dictates that you must use your common sense when noting the evidence. Members of the jury, I ask you to use this reason. The doubt needed to acquit Avery Becker must, by that instruction, be reasonable and real, not small or vague, and the evidence dissolves reasonable doubt. At the start of the case, my co-counsel Olivia promised the fulfillment of the prosecution's burden of proof. And in fact, the prosecution has done their exact jobs in proving to you beyond a reasonable doubt that Avery broke into her coach's home. A burglary ensued, but so did a struggle, and that the victim was murdered while Avery was there. As the jury, it is now your moral and legal duty today to convict Avery Becker of murder in the first degree. So the prosecution urges you to find the defendant guilty because Avery dealt with the devil and got burned. Thank you.
Thank you. Does the defense have a closing argument?
Yes, Your Honor, but before I begin, during my cross-examination, I forgot to mention I took a screenshot of the marked up Exhibit 16 for use in closing. Would it be all right if my trial technician screen shared that during my closing for purposes of argumentation?
Sure.
Awesome, thank you so much. Can the court see and hear me all right?
Yes.
My apologies, one moment. Too many questions, not enough evidence. Now, the prosecution just got up here and told you that Avery Becker had the motives, the means, and the opportunity to commit the crimes she has been charged with today. However, I'll ask you to remember those 3 questions we asked you at the beginning of trial. What about the alibi? What about the motive? And what about the investigation? These 3 questions prove that Avery Becker had neither the motive, the opportunity, or the opportunity to commit the crimes she has been charged with today. The prosecution simply brought you with too many questions and did not have enough evidence to answer them. Let's go by those questions one by one. What about the alibi? Today you heard from both Avery Becker and her best friend Taylor Perkins, who told you she was nowhere near Mr. Brackman's home the day of the murder. Now, the prosecution tried to bring in call detail records, or CDRs, to prove that Avery Becker's phone was at Mr. Brackman's residence. However, as you heard from Detective Markowitz herself today, Ms. Becker's phone could have been at multiple different locations that were not the scene of the crime and still would have connected to that bottom cell tower. Those CDRs can't tell us exactly where Ms. Becker's phone was the day of the murder. And even if the CDRs did tell us what we wanted them to, it wouldn't matter. On March 6th of 2020, Avery Becker was at the mall all day with Taylor Perkins looking for her phone that she had lost the day before. Professor Von Owens looked into Taylor Perkins' cell phone record and found that connections with her phone were made at the mall, covered a cell tower that was at the mall in Fry Shack, consistent with her alibi. Detective Markowitz didn't bother to check Avery Becker's alibi, didn't bother to look into the alibi of her primary suspect? Secondly, what about the motive? Today, the prosecution tried to bring up Exhibit 14 to show that Avery Becker wanted to wreck Mr. Brackman's home. However, you heard from Detective Markowitz herself today that she didn't use the extensive training she had in the Cellbrite system to download those text messages off of Mr. Cifuentes' phone. Instead, she simply trusted screenshots of those text messages. Screenshots that could have easily been doctored, messages that Ms. Becker denies ever even writing. What's more, you just heard from Avery Becker a few moments ago, and she just told you that in the days leading up to Mr. Brackman's murder, she was asking for his forgiveness. She wanted to apologize to him, not get revenge. Lastly, what about the investigation? Well, you heard from Detective Kuzak today, and he told you that he didn't find Avery Becker's fingerprints or DNA anywhere in the murder weapon. He didn't find Avery Becker's fingerprints or DNA anywhere at the scene of the crime. Detective Kuzak told you he didn't look into any other promising alternate suspects. The only piece of evidence the prosecution has that remotely connects Avery Becker to today's case are those call detail records, which we already showed you leave a lot of room for reasonable doubt. So we have an alibi, no motive, and an investigation with a lot of missing links. What does that mean for you, members of the jury, and the decision you should be making at the end of today's trial? Well, the prosecution carries the burden of proof. They had to prove to you that on March 6th of 2020, Avery Becker unlawfully trespassed Mr. Brackman's home and caused his death while unlawfully on his property. They had to prove both of these things to you beyond a reasonable doubt. Members of the jury, beyond a reasonable doubt is the highest burden in our criminal justice system. So if you thought it was odd, Detective Markowitz did not check the alibi of her primary suspect, that's reasonable doubt. If you wondered why Detective Markowitz chose to trust a key piece of evidence that could have easily been tampered with, that is reasonable doubt. And if you wondered why the prosecution could not find a single piece of evidence that actually connected Avery Becker to the scene of the crime, members of the jury, that is reasonable doubt. Prosecution had too many questions, not enough evidence. Find Avery Becker not guilty. Thank you.
Thank you. I'll ask the timekeepers how much time is remaining for prosecution rebuttal. All right, I see 1 minute and 3 seconds and 1 minute and 5 seconds. You guys have been extraordinarily close this whole time, and I appreciate that. I'm gonna go ahead and do 1 minute and 5 seconds. I'm hoping the 2 seconds won't make too much of a difference, but you may proceed.
Your Honor, opposing counsel, and members of the jury, Avery dealt with the devil and got burned. The defense tends to bring you 3 key questions today, and they tell you that the evidence can't possibly answer these questions as the prosecution has brought it up. But when we look at the testimony of the 2 experts who are qualified and testified for the prosecution, they both link Avery to not only the crime scene, but to the crime itself. And the experts tend to perfectly answer those questions. Firstly, of the question of the alibi, the CDRs negate that alibi completely, as was brought up by Detective Markowitz, who analyzed them and showed that the CDRs did not support the defense case, but rather the prosecution. In terms of the motive, the second question, Avery told her own mother she would get back at Brackman if it was the last thing she did, and she was angry. And finally, in terms of the investigation, Kuzak testified that it was thorough and complete. The investigation should not be called into question in terms of validity. Avery dealt with the devil and got burned. Thank you.
Thank you. And thank you, everyone. Everyone can take a deep breath now and exhale. And let me see if I can pull everyone back up again. I guess you can all turn your cameras back on and that'll do it. There we go. I think I flew through that a little bit, so I want to make sure our our scorekeepers have enough time to score. And while they do that, I'm going to buffer for a minute. Great job, everyone. I was a mock trial addict. It's probably still am. I don't think it ever goes away. I did 10 years of competitive mock trial between high school, college, and law school. So I appreciate everything that you guys have gone through and are going through. And I don't really have a lot of feedback for you. I think your coaches hate that when judges give you feedback in the middle of a tournament anyway. My only advice is just have fun. I know this is a weird circumstance doing it virtually, but just enjoy it. State is a lot of fun. These are great rounds. Obviously, everyone is super well prepared. And this is going to be some of the best competition that you have. So just enjoy it. That's my advice. And I think you all did a great job. And I know that you guys have all put in an extraordinary amount of work. So I appreciate that. I am currently a criminal prosecutor in Adams County. I've been doing DA work for 8 going on 9 years. So that's kind of my background. I judge these rounds occasionally. This virtual thing is new, so I apologize if I screwed anybody up with some of my rulings, especially on marking things up virtually. That was just new to me, so I apologize. And you guys rolled with it really well, so I appreciate that. And then if the scoring panelists could just let me know in the chat.
You're sharing your screen. I'm not sure if you mean to.
Yeah, that's not me.
I think it's Joel now.
Oh, wow. What are names you'll be telling me? Hang on.
Oh.
Stop remote support. I'm trying to get my camera back on. What is going on here?
Can you just turn off screen share?
No. Yeah, there should be a stop screen sharing button. It should be red and it should be at the top of your screen. Sir Varnell?
Let me get out of the...
That was the other comments I was going to make, though, while they're figuring this out, is I really wish you guys could be like IT for me and my trials, because you guys were flawless in moving everything around, getting everything up and off and marked. You know, I'm not like real old or anything, but you guys are great at the technology, and I wish I was that smooth with it. Yeah, I guess I just really just want to say great job. I hope you're having a lot of fun. This is such a fun problem from a mock trial perspective. I was laughing at that one witness, Perkins, I think, who did musical theater and mock trial. That was all my friends in high school. We would go from our musical theater practice to mock trial practice. So that was pretty much what we did. So it felt very relatable to me. And that's why I was laughing during her testimony. How are our scoring panelists? How are you guys doing?
I'm done.
Done? Mr. McLean? You're a pro. You're done, I bet.
Finished, yes.
Yeah.
I'm done.
Okay, perfect. Okay, they're all submitted?
Yes.
Okay. All right, so I can stop stalling now, and I will allow our lovely scoring panelists to impart some brief advice for you so we can all get on with our evenings.
Yes, you all are good to go.
All right, so
Want me to
I'm
go?
going to turn it over to the panelists, just if you have any input for our competitors.
I can go first. Can you hear me? Everybody? Okay. I thought you all did a really great job. My name's Jill Phipps. I'm a family law attorney in Fort Collins. I've been a family law attorney for 30 years. I've coached mock trial for 21 years. I've been retired from it for like the last 3 years. I'm not coaching now, but I coached Fort Collins High team for a lot of years. So I've literally sat through hundreds of these rounds. And you guys have done a great job. One thing I always harped on my kids about was having a good theme. And I loved both of your themes. I mean, the plaintiff, you had dealt with the devil and got burned. On the defense side, you had too many questions, not enough evidence. I thought you did a really good job of bringing those themes up in both of your openings and both of your closings. However, my one suggestion would be to bring them out in your questions also. I didn't catch your themes coming out when you were examining witnesses or cross-examining them. Take the other person's theme and use it against them in your cross. It's very effective. So going forward, I would just suggest that. I loved all the witnesses. Y'all did a great job. Some of you had really great personality. On the plaintiff side, Mr. Sorry if I butcher your names, Kreslik. Yes, you did you had great personality. I love the way you portrayed it. And on the other side, defense, Miss Walters, I thought you did a great job of portraying kind of a ditzy high school kid. Mr. Briggs, I thought you did a great job of being an ex with them, but you did a great job with that. What else? I don't want to take up too much of your time. Timing, watch your timing, both teams, especially on when the plaintiff was going. I think you may have cut your last witness a little short. So watch that you don't ask too many questions from your first witness so that doesn't happen. Also on cross, you came out a little bit short on that first round. You don't want to run out of time on the last witness. And so I felt like both sides were kind of, get your timing down, but that'll happen when you go through the competition. It'll get better. Lastly, just be aware, kids, of your facial expressions when you're not talking and you're on the screen. I always told my kids to do that all the time in the courtroom. Now you're not all on the courtroom, but sometimes like if you were cross or you were direct and you weren't the one speaking, guys had really strange expressions on your face. So be aware when you're on camera that, stay in that professional thing. But I thought you both did great. I bet you both do great going forward. So good luck in the next 3 rounds.
So I can go next. Sorry, I can't get my camera back on, guys, but so openings were really good. Everything was, I've been a lawyer for 40 years doing civil litigation. I've done this mock trial scoring about 10 times. I'm continually amazed at how good you guys are. Just really impressive. Great open-ended questions on direct. With respect to the openings, the plaintiff prosecution did a good job of previewing the witnesses. Braden, what really made your opening effective was your pace. You were nice and controlled, and it was so easy to follow you. So that was great, and I love the theme. I thought the theme was great. Now, as we progressed through the trial, I thought maybe the defense could have stuck with their theme a little bit better because it was a good theme. With respect to Detective Markowitz, Jaylee, when they challenge the credentials of your witness, all you have to do is ask your witness, okay, what's your training in this area? And then let the witness take over. And I thought everybody did a really good job of letting the witnesses be the stars, which is really important. A few more comments. Don't make objections unless it's really important. Okay, that's one thought. Stick to your themes on cross. Don't be careful saying I'm just going to ask a few follow-up questions and then you're 35 questions into it. So I thought all the witnesses were really good. I thought the witnesses really helped make this trial. You were all prepared and you were all. I didn't see one bad witness. I saw all really, really good witnesses. So you're really to be commended for that. Zoe, you did a really good job on cross of making the witness, limiting them to the question. You were very patient, but you said, that was not my question. I love that. That was really good. You have a really good temperament up there. That's a real strength. Don't voir dire an expert unless you're going to hit a home run. Okay. Let's see. I'm almost done too. Closings were excellent. I really liked the process. Zoe, on closing, you came right back and answered the questions that the defense raised. But I thought the defense was really effective in summarizing the evidence and rebutting the prosecution's case. But anyway, I was really impressed with all of you. Phenomenal. That's all I've got.
I enjoyed it. Thank you. I've been a civil litigator. Most of our practice is either in district court or in arbitrations, and this is the first time I've coached, watched, participated in, judged mock trial, and I think it was. I think you guys did great. It was very impressive. One thing I enjoyed about the defense, even though it's in a virtual world, strange to stand up in front of your camera, I think it allowed you to engage in more purposeful movement. If you're going to switch topics, moving from this side over here and kind of break the train of thought, or use that as a demarcation for moving on to the next topic. I enjoyed that. Mr. Kerr, I loved your opening. I mean, very clear and concise. I mean, Joel said it, easy to follow, laid it out. Here's the issues. Here's what we're going to prove. Here's how we're going to do it. Listen for it. Kind of set the tone for the trial to be able to think, here's what I need to pay attention to. I agree. I thought the witnesses all did great. I didn't get to see any impeachments. That's one of my favorite parts about trial. You know, and I would ask everybody as you get into and look towards the next round or the next trial, to really think as you're drafting those questions for cross-examination, what happens if the witness goes south? Where is the exact line number where I pull that open and impeach them? And if I can't, if it's not close enough to actually do an impeachment, how do I get out of this thing? There were a few times it just turned into this loop, kind of into a quagmire without a clear way out of it. I've got pages of notes, but I don't want to bore everybody. I mean, I think all throughout it, Ms. Bradich, I think I made a note. You know, there was an objection to your screenshot on an objection to the screenshot you pulled up. I think it was during your direct of Van Owen. And I thought your retort on the objection was fantastic, being able to think on your feet and kind of quash it. And then as soon as the objection was overruled, coming right back to the question and highlighting the fact that this bothered the other team enough for them to make an objection about it. If they lost, I'm going to come back and highlight this issue. The only comment, there were a few times where the questioning, especially on cross, distracted me a little bit when every question in cadence started with the word you or started with the word and. I would vary that up a little bit. And then, you know, if you are dealing with a witness on cross who's not giving you yes or no answers, then I think you need to start giving the verbal cues on the questions that this is a yes or no answer. Is that correct? And as much as I hate doing that myself, it really fences the witness in. And then if you don't get the yes or no, then it's easier to raise the objection with the judge that, look, this question fairly called for a yes or no. If they want to explain it, they can do that on redirect. This is my exam. I'm talking now. That's it. No, I thought it was great, and I appreciate the opportunity to be a part of it. Thank you, Ashley.
Thank you. And I piggyback one last comment and I'll let you all go. I think Amy said we're good to go. I think the lack of impeachment also speaks to the level of witness prep. The witnesses all were willing to I guess they knew their statements well enough and they didn't fight with attorneys. And I think that made you all look a lot better when you were testifying, that you weren't pushing back on what was actually in your statement and you knew your statement. So I think that's a testimony to the witnesses that there was not a lot of impeachment going on. So that's my last comments. Amy, are we good to go?
You are. I just want to thank everybody. Teams, you were great. Volunteers, thank you, thank you, thank you. We could never, ever do this without you. We really, really appreciate it.
All right, you guys have a great evening and good luck in the rest of the competition.
Thank
you.
Real quick, on behalf of both teams, we just want to thank you guys for being here and taking time out of your day for us. We really appreciate it, and we're so thankful to actually have this opportunity to do this year. So thank you guys so much.
It's a pleasure.
Welcome. It's my pleasure. Thank you.
Well, that was nice.
Have a good
Bye,
night.
everyone.
Thank you.